we're going to be talking about the next section of the rules, specifically communications about legal services. In this section of the rules will make up 4 to 10% of your total MPRE examination. So the first rule that I want to talk about is advertising and other public communications about legal services. And you'll notice that your outline first gives you a little information upon our history. And I want to point this out to give you some context here. So it tells you that up until the late 1970s, lawyers were prohibited from advertising. Now, lawyer advertisements are considered protected commercial speech. So this means while it's protected speech, it does not get as much protection under the law as, say, someone's political speech would receive. However, it is protected, which means lawyers can now advertise, assuming they are following other laws and these ethical requirements. So the government can place restrictions or regulations upon commercial speech. Remember that. So this means the government can regulate commercial speech so long as they have a substantial governmental interest and the regulation directly advances the interest in question and the regulation is narrowly tailored to meet that interest, then the regulation is lawful. So just to recap, lawyers can now advertise. Historically, they couldn't. Commercial speech is protected speech, but it can be regulated by the government. If you see some sort of regulation on commercial speech and you think it's being tested in terms of its constitutionality, apply the test that's outlined above. The government must have that substantial governmental interest. The law or regulation in question must directly advance that interest, and the regulation must be narrowly tailored to meet that interest. So now that lawyers can advertise, as we've just learned, these rules do put parameters on what we as lawyers can do with our advertisements and our public communications to people. So the next rule that I want to talk about is what we can write in our ads or in our advertisements. So the rule says lawyers can communicate information about their services through any media. And what we can say is information concerning the lawyer's name or their law firm or their address, websites, emails, phone numbers. It can contain the kinds of services that the lawyer can undertake for the public, the basis on which the lawyer's fee will be determined, including prices for specific types of services and payment and credit arrangements. It can outline the lawyer's foreign language ability if they have that. And names and references of clients that are regularly represented, so long as the lawyer has previously gotten consent from those clients to use their names. And lawyers are also allowed to include any other information that would invite the attention of those seeking legal assistance. So let's just stop there. We now know lawyers can advertise, and they can advertise through any means. So billboards, commercial ads on the radio, commercial TV ads, in a newspaper, in a magazine. All of that's permissible. And when it comes to what a lawyer is allowed to say in their advertisements, I want you to think of this with some common sense perspective, that they're allowed to basically provide information that would help the public contact them or would invite the public or people needing legal assistance to contact that lawyer. So the next rule I want to talk about says that a lawyer shall not give anything of value to a person for recommending the lawyer's services. So I just want to stop there. Generally speaking, lawyers cannot provide referral fees under the ABA model rules. Again, I know some jurisdictions and specific state rules allow lawyers to pay other lawyers referral fees or other people referral fees, but these ABA model rules do not allow that. Please focus on the basic words here. It tells us lawyers shall not, so strong words, give anything of value to a person for recommending their services. But then the rule carves out some exceptions. And the way I like to think of this rule is that we interpreted it very literally. But then we realized it didn't make a ton of sense if we kept that interpretation as literal as we had it. So we had to backpedal a little bit. So it goes on to tell us that you can, as a lawyer, pay the reasonable costs of advertisements or communications that are permitted by this rule. So let's stop there. The rule directly prior to this says that we are allowed to advertise as lawyers. This is a form of protected speech. But then the rule thereafter says you can't pay anyone to advertise. So that doesn't make much sense. So they carved out an exception that says you can. We understand that advertising costs money. For instance, if you have a commercial, you have to pay to have it aired. So you're allowed to pay those costs and fees that are associated with advertising under these rules. Look at your example that the outline provides. It says lawyers may pay for the costs of print directory listings, online directory listings, newspaper ads, television and radio airtime, domain name registrations, sponsorship fees, internet-based advertisements, and group advertising. Lawyers can also pay people like publicists, public relations personnel, business development staff, television or radio station employees, or spokespersons and website designers. So you can pay these people to help you advertise your services. The next part of the rule says that you are allowed to pay the usual charges of a legal service plan or a not-for-profit qualified lawyer referral service. So not everyone may be familiar with what this is, but so I'll give you a quick example. Many jurisdictions have like a lawyer referral hotline that the state bar, say, advertises. Usually it's like a 1-800 number. And what the public can do is they can call that phone number and they can tell the operator, what type of lawyer they're looking for and where they're located, geographically speaking. And then the operator will provide that person with a list of attorneys' names and their contact information. So that person can turn and contact whichever lawyers on that list that they want and can inquire about those lawyers' legal services. So what this rule is saying is that you are allowed as a lawyer to participate in this type of arrangement, and you're allowed to pay to be part of it. So most lawyers have to pay to become part of these referral services. And again, that's permissible under this rule. The theory behind it is that it's understood by the public when these types of arrangements are made to be consumer oriented, and they're supposed to be providing these unbiased referrals to lawyers with appropriate experience in the subject matter requested and afford other client protections, such as a complaint procedure or malpractice insurance requirements. And consequently, this rule only permits a lawyer to pay the usual charge of or a not-for-profit or qualified lawyer referral service fee. So because there are safety procedures or safety nets in place here for the public, a lawyer paying to participate in one of these is absolutely ethically permissible. The other thing I want to point out is the note in your outline. So it tells you that lawyers can compensate non-lawyers for generating client leads, as long as that non-lawyer does not recommend the lawyer's services. So in other words, there is no referral or improperly communicates with those potential clients. So this is a rather new update to the rule. So I want to give you a quick example. Let's say there's a law firm that regularly represents businesses in business transactions and with other issues that might arise in their clients' businesses, generally speaking. So this law firm who specializes in this type of work could hire a company to generate client leads for them. And they can pay that company an hourly rate or a flat fee or whatever their arrangement is. So let's say this company goes through the phone book and writes down the name and contact information for every sort of business out there that might benefit from this law firm's services. And then that company gives that list to the law firm. That's absolutely fine. That would not be in violation of this rule. Getting back to the rule, lawyers shall not give anything of value to a person recommending the lawyer's services, except that a lawyer can pay for a law practice in accordance with these rules. So we learned in previous sections of the rules that lawyers can sell and buy law firms and portions of a law firm practice, so long as they're complying with the requirements of the rule. So you can exchange money in this type of transaction. You can refer clients to another lawyer or a non-lawyer professional pursuant to an agreement not otherwise prohibited by these rules that provide for the other person to refer clients or customers to the lawyer. We call these reciprocal referral agreements. So these are permissible under these rules if you meet the following requirements. So let's talk about those requirements. These reciprocal referral agreements can't be exclusive. So let's say lawyer A and lawyer B are going to refer clients to each other. They can, but they can't only be referring clients to one another, because then that will be exclusive and therefore violating this rule. The second requirement to have a proper reciprocal referral agreement is that the client has to be informed about the existence and the nature of the agreement. So if you're going to refer your client to a specific chiropractor because of this reciprocal referral agreement, you need to tell your client that's why you're making this representation. So they know this agreement exists between you and the other professional. The third requirement is these reciprocal arrangements must not interfere with the lawyer's professional judgment as to making those referrals and providing legal services. So the idea here is you as a lawyer, regardless of this agreement, need to continue to work in your client's best interest. So you can't let one of these reciprocal referral arrangements or agreements get in the way of doing what's best for your client. So for instance, if referring your client to a certain chiropractor is not in their best interest, even though you have one of these reciprocal referral agreements, you shouldn't refer your client to that chiropractor then because it's not in their best interest and you need to make sure it's not interfering with your professional judgment. Additionally, these reciprocal referral agreements, to be proper under the rules, cannot be for an indefinite duration, and therefore they should be reviewed periodically to determine if they're still a good idea and if they are still in compliance with the rules. So the other thing I want to point out, we have seen some questions floating around out there that require you to understand that in order to have a proper reciprocal referral agreement, the lawyer has to be engaged in one of these agreements with another professional. So you're talking here like lawyers, doctors, accountants, real estate agents, and the like. If the lawyer enters into this arrangement with a restaurant owner, for instance, that person's unfortunately not considered a professional under these rules. And then the final section of this rule that we're discussing says that lawyers can give nominal gifts of appreciation that express their appreciation that are neither intended nor reasonably expected to be a form of compensation to someone who recommends the lawyer's services. So to be clear here, the rule goes out of their way to tell us that these gifts that a lawyer may provide to someone who's referred that lawyer or the lawyer's services are really supposed to be nominal. And it cannot be the type of thing that's given to compensate the person. So here you're talking about truly like a nominal gift or gift that you would give at a holiday, anything else that would be appropriate under normal like social hospitality rules. So let's say you have a client that you represented in litigation, and let's say you were very successful on their behalf and your client was really happy, and your client happened to refer one of their friends to you, and that person hired you, and you found out that you generated that client through your past client. So what you could do is you could send flowers to your past client. You could send cookies or a cake or a pie to that past client as like a thank you. Why? Because it's a nominal gift. It's just expressing your appreciation, and no one would construe that as intending to be compensation for the referral. So the next rule here in this subsection of rules that I want to discuss is about solicitation. So first, let's talk about the basic definition. The rules have been clarified here, which is really nice. So solicit or solicitation denotes communication intended by or on behalf of a lawyer or a law firm that's directed to a specific person that the lawyer knows or reasonably should know needs legal services in a particular matter, and that offers to provide or reasonably can be understood to provide as offering legal services for that matter. So the general rule here is lawyers shall not, so there's strong language, solicit professional employment by live person-to-person contact when a significant motive for the lawyer's doing so is pecuniary gain. In other words, to make money. Let's just stop there. So if you are by live person-to-person contact approaching someone and asking them to hire you, meaning they're going to pay you, that's problematic under the general framework of this rule. Now, if you go up to someone person-to-person, so we're talking live person-to-person contact, and you offer to represent them in their legal matter for free, well, now that's not soliciting them for your pecuniary gain, and therefore now you're not in violation of the rule. So let's say there's a whole bunch of people protesting and you see someone get arrested, and you firmly believe, based on what you just saw, that they're First Amendment rights have been violated. So maybe you approach them and you say, hey, I'll represent you, call me, and you hand them your card and you say, I'll represent you for free. I feel very passionate about what you're doing. Well, then this is fine. This is a live person-to-person contact, so it's definitely solicitation. But because you're offering your services for free, because maybe you happen to feel very strongly about what's happening, then you can do that. So getting back to the rule, it says that you can contact certain people or you can solicit certain types of people. So a type of person you as a lawyer can solicit by that live-to-live person contact is another lawyer. And I'm going to stop there. The theory behind this is a lawyer should understand these rules. They know how operating a law firm works, and they're not the type of person that might be harmed by this live person-to-person contact. So you're allowed to solicit them. Or you can solicit someone that you have a family or close personal relationship to, or some sort of prior business or professional relationship with. So let's stop there. If you want to talk to your cousin and solicit them face-to-face because you know they're having a legal problem, you can do that. Why? Because they're your family member. Or maybe one of your good friends is in need of some legal help and you want them to hire you, you can contact them. Similarly, if you've previously represented a client and you know they're in need of legal services again, you could permissibly solicit them. And then finally, you're allowed to solicit someone who routinely uses for business purposes the type of legal services offered by you or your firm. So to be clear here, if there's someone maybe you don't have a prior relationship with, but you know that they're the type of business or the type of person that needs the services that you provide, and they've frequented those types of services in the past, again, not maybe with you, but with another law firm, you could solicit them as well. So I want to talk about some of our examples here just because I think they're very helpful. So turning to the first example, it says, lawyer sends his secretary to a funeral home to ask the father of an accident victim if he wanted to sue for wrongful death. The lawyer has no pre-existing relationship with the father. The lawyer here planned on charging the father a fee. The lawyer is therefore subject to discipline. Why? Because the person being solicited was solicited live, face-to-face, to make money or that pecuniary gain, and it's not the type of person that falls within this list of exceptions. Now, using that same example, much like the example I've given you before, if the lawyer planned on representing this father for free, now there's not an ethical dilemma raised by this situation. Turning to the third example, a person who routinely uses for business purposes the type of legal services offered by the lawyer are persons who routinely hire outside counsel to represent the entity, entrepreneurs who regularly engage in business, employment law or intellectual property lawyers, small business proprietors who routinely hire lawyers for lease or contract issues, and other people who routinely retain lawyers for business transactions or formations. So again, you could solicit these people and not be in trouble for that action. I want to give you one more example before we move away from this rule, but this is not an example in your outline, but instead just one that I think is further helpful. Let's say that a lawyer lives next door to someone who was on a plane when it crashed. And many people survived, but they were very badly injured by virtue of this plane crash. And let's say that person, the neighbor, was part of a online group community who offered each other support, who had been hurt in this accident. And the neighbor knew that his neighbor was a lawyer and said, hey, you should join our online community and you should let everyone know that you're a lawyer that helps accident victims. So maybe they'll be interested in hiring you. Maybe, you can make some money off of this situation. So the lawyer joins that online community and makes a post in the chat room that explains that this lawyer has, the ability to help out accident victims, provides contact information, and basically offers to help anyone for payment who might be interested in his services. Is there a problem with the lawyer's actions here? Did the lawyer's posting in this chat room or online forum amount to behavior that is in violation of this rule? And the answer is no. Why? Because they've clarified what solicitation means. Solicitation means live person-to-person contact. So while technically this lawyer was trying to drum up business, he wanted these people to pay him for his representation. But because he posted this type of ad essentially in a chat room, That's not live to live person solicitation. Therefore, what he did was okay. He did not commit any sort of ethical violation in that action. The next rule that I want to talk about is still talking communications about the lawyer's services, but more specifically that their communications cannot be false or misleading. So the rule says a lawyer shall not make a false or misleading communication about the lawyer or the lawyer's services. And a communication is false or misleading if it contains a material misrepresentation of fact or law, or if it omits a fact necessary to make the statement considered as a whole not materially misleading. So just to stop there, please remember that this rule has the word or in it. So this means that sometimes a statement might be truthful, but it's misleading. And that's a problem because your statement needs to be truthful and not misleading. Okay? So keep that or in mind. So a few examples I want to talk about that are in your outline. The first one says an advertisement that truthfully reports lawyers' achievements on behalf of clients or former clients may be misleading if it's presented so as to lead a reasonable person to form some sort of unjustified expectation that the same results could be obtained for other clients in similar matters without reference to the specific factual and legal circumstances of each client's case. So to stop there, I'm sure all of us have seen commercials where a lawyer has a client get on the screen and talk about how much money the lawyer won for them. And that's okay as long as the lawyer is taking steps to not create some sort of unjustified expectation. There needs to be some sort of communication that outcome was very specific as to the client's facts and circumstances surrounding that case. Look at your next example. An unsubstantiated comparison of the lawyer's services or fees with the services or fees of other lawyers. For instance, if they say something like, our firm wins 20% more cases than any other firm in the state, they may be misleading if it's presented with such specificity that would lead a reasonable person to conclude that the comparison can in fact be substantiated. The inclusion of an appropriate disclaimer or qualifying language can preclude the finding that this statement is likely to create that unjustifiable expectation or otherwise mislead the public. So again, having a disclaimer here, if you want to report your statistics, for instance, is going to be very helpful to make sure that you're in compliance with this rule. So that wraps up our discussion about this subsection of the rules.